Hi, my name is Noreen Bomer. Welcome, everybody, to our last leg of our conference. I'm very pleased today to be able to do this presentation with two great lawyers and a wonderful judge. Very honestly, they do all the work. That's why I love doing things with them. I don't have to do anything. So, anyway, I don't know, I'm going to say this before I do the introductions, but it's going to lead into our story here. How many of you have looked at our ethics, our code of ethics through the Bureau since you first became a fiduciary? Raise your hands. Oh, okay. Well, I hadn't looked at them until we started this presentation, and then I went, oh, okay. You know, it's been a long time since they were created, and we've been doing this a long time, so I hadn't looked at them. So I think this is a very timely presentation for us. So I'm going to introduce people out of order here of that. Next to me is Yevgeny Belos. We call him Eugene, though. It's easier. He works at Nielsen and Rogers, Woodland Hills. He's one of the attorneys that represents our firm, and him and John Rogers and Karen Nielsen have represented us a long time. One of the things for newbies I want to let you know is make sure when you find a lawyer to represent you, it's a lawyer that's not just a lawyer that does estate planning. It's a very specific niche to have a good lawyer to represent you, and we find their law firm does a great job. Lorianne Wright, who also does some representing of fiduciaries, but her claim to fame is litigation. That's why she's so good at this stuff that we're doing here. She has plans for us, so watch out. Anyway. Yeah, now you're in trouble. She has a law firm, Wright Kim Douglas in Pasadena. I think you have 9 lawyers now? Yeah, 9 lawyers. So growing like all of us hope to. And last but definitely not least, Judge David Cowan from Los Angeles. He's the supervising judge of the Los Angeles Superior Probate Department. We're very pleased to have him. I don't believe PFAC has ever had a sitting judge before. We really appreciate him coming. And Judge Cowan is very good at what he does. He became a judge in 2014 and is already a supervising judge. So he does good work. I also have a gift for him. So I'm going to give this to you, Your Honor, so you can keep us in line. Okay?
One of the things about that you learn as a new judge
Microphones, please.
is that if you ever have to use a gavel, you've got a problem. So, keeping control of the courtroom means you should not need to rely on a gavel. But I appreciate the gift.
Okay, Lorianne, will you start us off?
Sure. So our topic title is Fiduciary Neutrality. It started with just the concept of the title, and it kind of grew from there. And our byline is When to Join the Fight, the Ethics, Law, and Practice of Neutrality. So we're going to start with some initial thoughts, and I'm going to pass the microphone to Judge Cowan.
All right, thank you. Good morning, everybody, on Saturday morning. And thank you for inviting me to your conference. And I was definitely wanted to come and have this opportunity to talk to you because, as you know, fiduciaries is a critical, central part of what we do in probate court. And so it was of interest to me to really kind of try to start to focus in on some of the issues that you have to deal with on a daily basis and that we have to judge on a daily basis. And so appreciate the opportunity to do this. As most of you probably already know, the probate court, the way I like to look at it is not only is it a court of equity, but one of the central themes that we deal with is looking after people who often are not able to look after themselves. And so in some sense, the judges too are, sometimes I've heard us refer to ourselves as super fiduciaries in the sense that we're trying to make sure that the fiduciaries act as fiduciaries. So I think that this concept of looking after people who sometimes may not be able to look after themselves translates very nicely into what I see as your jobs. And that is that you really, in our eyes, I think, I'm not speaking for all judges, but I'm just using we generally. I'm just speaking for myself here, not for the court either. But that being said, a fiduciary, I think it learned in law school, really holds a special place in the eyes of the law. You're not just transacting business with a customer. You have a client, not a customer. And the client is entitled to be able to put himself or herself in your hands and know that they can trust you and that you are going to put their interests ahead of your own. To me, that's the central but very critical point that distinguishes you from other business people who appear in the probate court. And so we're going to hold you to that standard. That's, to me at least, is why you're getting the fees that you're getting paid. And so we're going to hold you to that standard. And there's advantages and consequences relating to that position that you hold. The advantages are going to be that I think it's fair to say that generally speaking, we are going to give you some latitude in terms of the business decisions that you make on behalf of your clients. We expect that as fiduciaries, licensed, gone through ethics classes like this, that you're going to hold those fiduciary duties dearly and not want to waste them or put them in jeopardy. And so you're going to get some latitude. People are going to respect the difficult decisions that you have to make, that you're above the fray, and unlike the family members whose interests that you're looking after and that you have to work through, that you're going to keep in mind your license, your standing, and put that first over and above the demands that sometimes, and difficult demands that we know that you have to face sometimes from difficult or for clients who may not understand or appreciate all of the areas that you have to think about. On the other hand, I think you also need to know that as a court that protects the interests of those who may not be able to look after themselves, there are going to be consequences if you don't follow the rules. The California Probate Code is quite strict about the consequences of a fiduciary not following his or her responsibilities. And so the probate court is going to jealously guard and make sure that the interests of our wards or conservatees are satisfied. And some of the things that we're going to talk about today in terms of attorney's fees, your reputations, and the consequences both from court orders and just from the whole process, really we're trying to keep you away from that. And I think we're all going to here to try to show you some red flags if you're not already aware of them, that so you can avoid appearing in front of myself or my colleagues, which we want you to do, and be able to, for the clients to be able to rely on you, for you to work through the different difficult issues and not have to be in court. And kind of lastly, I would just say that to me, I was thinking, well, what do I want to say that kind of as a takeaway here in terms of ethics? And I think whether you're a lawyer, you're a judge, you're a fiduciary, I think that, to me at least, it's is if you've got some nagging feeling in the back of your head that maybe that you learned in school or somewhere early on in life or from your parents, that maybe I shouldn't be doing that, you're probably right. You shouldn't be doing it. And so look to your consciences and think about, how is this going to be perceived? Am I taking advantage of a situation? Keep in mind, it's not whether you are taking advantage, it's what's the perception of whether you're taking advantage of somebody. And some judges are going to hold you to this even more than I might, and are going to really expect you to follow these kind of general guidelines. So there's plenty of business out there, and I think that you need to take the long road in terms of your reputations, and that if sometimes you just need to say no. And sometimes I know that's difficult. I've been in private practice. I know the demands of getting clients and so on. But it's better to take less on one case and then not it become a liability, and then keep your reputations. People know that you can say no, and then you're going to get more business. So, try to take that long road if you can. Thanks.
Oh, that's a lot to live up to. That's a lot to live up to. You even got clapped for his section. Well, so then the next slide is, what does it mean to be neutral? And when I thought about this, sometimes maybe it's not just the pure neutrality, it's the appearance of neutrality. You arrive on a scene in a really messy family fight, and I think, there's the things you don't see that happen in the hallway, Your Honor. And a lot of that is the fiduciary meeting the family members for the first time, and they're huddled up on opposite ends of the hallway, right? Because they're not speaking to each other. And one batch of family members have mom really close to them. And I watch my fiduciary clients in the hallway and what they do, and they try to maintain that appearance of neutrality and go talk to both sides. Maybe one side did nominate you, but you don't want the other side to have a perception that you're in their pocket, right? And I think it goes a lot to calming down these tense family situations. When you have that appearance, you speak to both sides, and it is like therapy, right? They're for the first time telling their story to someone who's listening. That's my bad sister. This is why they're bad. Someone's listening. And I think it really goes far to calming down those tensions and getting people somewhat rational and starting down the road of solving the problem, right? So I think neutrality is a balancing act, because as much as you do want that appearance of neutrality and listening and holding off on judging who the bad kid is, I know, what I've learned after representing and being around fiduciaries for a while? You people are bossy. You're bossy people, right? And you got to hold off. It's so easy to judge that's the bad kid, but you need to kind of hold off on that and see all the facts. And sometimes life is a lot more gray than black and white. I think that's part of keeping that open mind and that neutrality. And then there's the balancing act. It was an eye-opening for me to read your ethics rules. They aren't that neutral. They're very clear that if the elder or the conservatee has a claim, you must pursue it. It doesn't say don't pursue it if the claim's against a family member. You pursue it, and that's not exactly very neutral. So you are, I think, doing a really important balancing act of a perception of neutrality on the exterior, but you still have to pursue claims and do things that need to get done. I'm going to pass it off to Eugene.
Good morning, everyone. And, I was pleasantly surprised to see how many hands went up when Noreen asked how many of you have read your ethics rules. They are, in fact, as Lorianne said, very strict, and they're very concrete on many points. These are the rules that govern your profession the same way as the rules of ethics govern the profession of attorneys. And in many ways, your rules don't have as much water in them as ours do. There are very concrete sets of instructions for very concrete circumstances, many of which you guys will see every day. What you should do in the context of a conservatorship, what you should do in the context of a guardianship and in a trust. And ultimately, as Judge Cowan remarked, your duty is to your consumer, which changes context depending on which category we're talking about. But essentially, they're largely the same, and they're very strict. And I won't spend too much time going through the specific rules, and sitting here and reading every one of them to you wouldn't make much sense, but I think what we should do is go through a few of the rules that we've seen touched on in many of the hypos that we want to address today. And I would highly, highly encourage each of you to familiarize yourself with these rules, because there could be a situation where your legal duty is telling you to do one thing, but your ethical duty is telling you to do another. And these situations exist more often than I knew. And we were surprised going through our presentation and preparing it just how many different circumstances where these things can come into conflict. But as Judge Cowan, I think, correctly says, go with your gut. If you think something is wrong, do the right thing. And there's many mechanisms that you can use to protect yourself if you have a question. The probate court is a unique entity, especially in the idea that you can ask the court to give you instructions, to bless your actions where you're not 100% sure which route you should take. So going to a few of the ethics rules that we wanted to highlight, there are the general principles, which I think are an important place to start, and those tell you where your duty lies and to whom. The other very important standard that you have to go by is your decision standards. That's section number 4472. You're representing another individual in one context or another. So you must absolutely do your best, and this rule tells you in very concrete terms, to try to go with the preferences of your consumer, whether that be the conservatee, the ward, the beneficiary of a trust, whether it's the children or the settlors of this trust. The idea is that you have to try to do what your client wants you to do. There's certain circumstances where you can act in their best interests, but as in most circumstances, you are representing a principal and you're an agent. Sometimes you step into that individual's shoes and you're making the decisions on their behalf, but in every circumstance, you have to try to do what's best for them and try to honor their wishes. Another very important set of rules is to make sure that you're not running into conflicts of interest. Our rules as attorneys are pretty black and white as well. We have direct conflicts and we have potential conflicts, and we're to avoid both sets of conflicts, but your rules take it a step further. You must avoid direct conflicts, and that's pretty straightforward. Most of those jump out at you. But there's also a very interesting item here, and the item is that you shall not participate in any activities where there is a reasonable belief or there could be a perception of a conflict. Now, that's a third party's perception. That's not your own, and that could be a very difficult thing to live up to. It makes you have to be extra careful when you're looking at a situation like Lorianne was describing, when you're sitting out in the hallway before the court hearing starts and you're talking to one beneficiary or another, or one party's nominated you to come and act on a case, and there is this perception, perhaps, that you are not neutral. And that's something you have to try to avoid, and in some situations it's not going to be easy to do because you can't control other people's perceptions. So
just kind of chime in on, you can have something as small as should you be sitting next to somebody in the court hallway? I've heard that many times. People say, Mr. X was seen sitting next to the sister, not the brother. So,
and that's the way it turns out sometimes. You'll have people address you and say, well, you're obviously on this person's side because here you are sitting right by them in the hall, or you've spent 10 minutes with them and only 5 minutes with me. Sometimes you have to spend a few extra minutes because there's more things to talk about. But the idea here is to try to keep your head above water and make sure that you're standing in a position of neutrality, because largely where you land in a case, especially if there's dueling siblings or some situation where you're brought in because of the conflict, is going to probably determine who is going to win. That's something that litigators will tell you. It's the neutrality aspect of a professional fiduciary is why you're brought in, a lot of the times as a placeholder to make sure that things don't fall apart when people fight. Moving on to a few other, and we'll get into those issues a little bit more in our hypos, but moving on to the residential placement and the treatment parts of your rules. These largely mirror the conservatorship rules when you're dealing with whether to place your charge, your consumer, the types of care standards that you have to live up to. For those of us who practice in the probate court and deal with conservatorships and even minors cases, the guardianships, you'll see that these rules essentially were taken directly from the probate court and the probate code. So the court's very familiar with what your standards are. And it's always going to be least restrictive, and you're always trying to make sure that you give the people that you're in charge of the most independence that they can have. But read these rules carefully. We'll caution you to look at them because they're very specific on your specific responses that you have to do in specific situations. And then one final comment I'll make about management, the estates, and the things that you should be doing. And this is a general point that all of us should take to heart whenever we're doing anything. Get the right help for the right job. Make sure that you are finding people who are the right professionals to deal with the right cases, because that's one of your ethical duties in black and white written within the Code of Ethics. Make sure that you understand who you need and what you need them for, because it's very easy to end up loyal to a person who's giving you a lot of cases or to a particular set of professionals. But like Judge Cowan said, take the long road. developing business with other people is also wise. And it's also wise to make sure that if you have a complicated tax question, you're getting a tax attorney involved or a CPA involved. Don't just rely on the idea that a one-stop shop attorney or financial advisor or care manager can take care of everything for you. Get the right people in for the right jobs and do your best in a situation to try to make sure that the right people are in place.
Again, you're not amateurs, right? You're professionals. So as professionals, we expect you to know when you can and cannot do something. Professionals will bring in other professionals. Nobody can be an expert at everything. We all know how complicated businesses can be. There's different kinds of businesses that your clients are going to be involved in, whether it's real estate, you name it. There's so many different businesses out there. So sometimes it's going to pay as a professional to not try to do everything and to get some help. It's okay to get help. In fact, it probably means that you are meeting your duties because you're recognizing some of you perhaps having some limitations. We all have limitations. What's key is to recognize them.
Okay, so we're going to move away from the ethics rules for a bit. We encourage you to read them very carefully because they're very specific. And we're going to go with just a little bit of law here. We don't want to bore you too badly, but we think that it's important to address some of the key points as they relate to you and your role in cases. So I'm going to read you a quote from the California CEB, and it's something that we thought about, and it kind of struck us as a perfect point when going through a lecture like this. It's the top of the slide here, and it's often the key to obtaining a favorable result is obtaining the support of a neutral fiduciary holding the assets in question. The executor or trustee has the assets of the estate that can be used to defray the costs of litigation, has access to records, holds medical and attorney-client privileges of the trustor, the settlor, the conservatee, or ward, and has the aura of an impartial party to distract attention from the unclean or greedy hands of another party. Now, that is something that we think highlights this whole discussion. Your role is to stay above the fray and to see yourself as the neutral. And if you are perceived as going one way or another, you hold all the cards, you hold all the assets, you hold all of the privileges, which is also very important. And every time a litigator brings, or even administrative attorney or a judge brings you into a case, the idea is to bring you in to make sure that the individual gets taken care of, not to be another litigant to take sides. Ultimately, you may have to, but try to stay as neutral as you can for as long as you can be.
Okay. As you can see on the slide, it's a family member versus a PPF. We, of course, would always vote for a PPF, depending on the case. Many times, family members do really well in certain instances. We've had cases where the family member has continued to be the conservator of the person. We've been conservator of the estate, which works many times, and we end up actually helping the family members do their job as we would do it as a professional, making referrals for them, helping them find caregivers, helping them find care facilities, things like that, so that, it does reduce the cost. However, a family member doesn't have our skill and doesn't have the training that we have. So unless they have a special skill, like if a family member, for instance, if somebody had a daughter who was an RN, then that would make sense that they could, possibly be the conservator of the person. Excuse me. One of the other issues that comes up frequently is the affordability of a conservator or a trustee, especially in conservatorships it comes up, because conservatorships can be very expensive, as all of you know. The cost for home health care has gone up tremendously because of a lot of new labor laws. A conservatorship, I remember when our licensing first started, there was a discussion and many people stopped taking conservatorships. I'm sorry, because it was going to be so expensive. And it is expensive. We at our office call conservatorships front-end loaded. That's what we call them, because they are front-end loaded. Usually in a conservatorship, unless it's terribly, a problem afterwards, once you get the person settled, once you get everything done, it's not as difficult. But if you continue to have a warring family, then it is more difficult. So one of the things everybody would look at, and Judge Cowan, the size of the estate is part of the factors, the split between the person and estate, and and then there's a case law regarding whether a conservator has to be a family member if they're available. So perhaps, Your Honor, you'd like to speak more on that.
Again, generally speaking, I think that the courts often may prefer a family member over a fiduciary if in the case where there's limited funds. Unless there's some reason to, which there often may be, to bring in a professional. The contentiousness of the case is a prime example where sometimes we have to bring in a PPF, notwithstanding the fact there are limited funds, because the matter is out of control, and we need to have somebody come in and control the damage, and the estate may be diminished as a result, but I cannot let something that is get even worse when I see a battle. So sure, it's going to be costly and the estate is going to have to pay, but we're still mitigating the problem to some degree by bringing in a professional. So the court, I should just say, speaking for myself, I think that we are receptive to family members' feelings that they want to be in charge of their own families for natural reasons. At the same time, depending on the complexities and if there's enough money involved, or there is some ongoing business or real estate situation where a professional can come in and act as the landlord, or if there are accounting issues where they can come in perhaps just for some discrete function. We do have the idea of a special trustee, or we can limit a conservatorship to perhaps fashion something so that to address a particular problem, or have a conservatorship for a limited period. I mean, we have a lot of, the creativity does exist in probate, and we can try to fashion things so that to tailor it to the particular situation.
I would like to say one thing about, go back for a moment to neutrality. In our practice, what we found is, and many of you have the same all the time, warring families. When you can go in there as a neutral, you become in charge of the money, you're in charge of mom. You take away the energy and the negativity that has existed frequently, and you give the family an opportunity to heal themselves. And it does happen. It's the finest moments that we have is when that happens. I'm sure many of you have experienced it.
So briefly, I want to talk about the attorney-client privilege. And so when you have a lawyer, anything you say to that lawyer remains confidential. But the caveat to that is it's almost like you have a crown on your head. You're filling an office. When you're a trustee or a conservator, it's the office of that role. It's the office of trustee. And so there's a case called Moeller that was out many years ago, actually, that holds the privilege follows the office of trustee. So let me highlight what this means. Let's say you're a trustee and those family members are really making you mad. I could use some other words. And how about you email your attorney, that son of that son's driving me crazy, and maybe use a few curse words. There it is in writing. And then let's say you get removed as trustee and a family member replaces you. They can get your lawyer's entire file with that email in it. And let's say you were removed and there's a surcharge pending. They get that entire file. So you can kind of get the issue here. So be really careful what you put in writing. For any other type of attorney-client relationship, you really don't have to worry so much what you put in writing. But because The privilege follows the office. Someone else may get your communications with your lawyer. So if you really want to tell your lawyer what you really think about those no good kids, call them, telephone. All right? Don't put it in writing. So there's also, yes, Eileen? All kinds. Yes. The attorney-client privilege follows the office. I would think it would apply to any fiduciary role. Your role as a fiduciary is in office. It's not you personally. So we have a new case that just came out a few months ago, Fiduciary Trust International. I think there's some people here from that trust company. There she is. They have made law. And just really briefly, it was a surcharge situation. We finally have some, at least, direction about if you do want to preserve that privilege, how you can do it. And the case hedges a little. It doesn't say, well, for sure this is going to work, but probably will work. So it distinguishes between administrative and defensive legal services. So administrative is, the day-to-day, how you're managing things, the investments, the attorney-client communications on that. But let's say someone's filed objections to your accounting and they're asking for a surcharge. Well, that's defensive work for your lawyer, right? They're coming after you. And you want to really, for sure, those are the communications you want to protect. So what the case says is there's 3 things you can do. And if you do all 3, I think for sure, you're going to preserve that privilege. And I'm going to pass it to Noreen in a second to tell you the practical side of this. But the 3 things are, number 1, you have to hire another attorney. You get a separate attorney just for your defensive work. Number 2, you pay that attorney yourself. Don't use the trust money. Because once you use the trust or the conservatorship money to pay that attorney for defensive services, there's a good argument those services belong to that office, right? So pay them out of your own pocket. And number 3, mark your communications defensive attorney-client privilege. There's nothing like actually putting it on the face. Hey, this is what this communication is. It's not administrative. So then later, and the judge has to deal with this, and sometimes judges do in-camera review, meaning without anyone else seeing, they alone look at the documents and decide what come in and what doesn't. Hey, it's marked right on it. I think it's pretty clear what the intent is. I intended this one to be private. So, Noreen, what's the practical impact, do you think, of this decision?
I think the practical impact is our insurance that many of us have, our malpractice insurance. And I do believe we happen to be insured through Dominion Insurance, which is through Lloyd's of London. And when there's a problem, you would always want to get a lawyer, as Lorianne said. They will pay for separate counsel. That's what they do. If you have a problem, if you end up in litigation, if you end up in some of these issues, they pay for separate counsel, which does solve one of the issues that Lorianne is talking about in Mueller.
I would just add here that while Lorianne presents a obviously costly and another wrinkle that you don't want to have to deal with, I'm going to give you a good side here, which is that just because somebody may get your document or a communication with something in it that you might not have otherwise wanted to think would be public later, we get that you need to get the advice of a lawyer. There's nothing wrong with getting the advice of a lawyer. You should continue to get the advice of the lawyer. The law encourages you to seek the advice of a lawyer. So while there are some wrinkles here about who gets to see these communications, just like I said at the beginning, we're going to give you latitude when we see that you do the right thing. So don't stop asking your lawyers for advice. You should be doing that. That's normal. But what we're also saying is that life is complicated, and so there are wrinkles here, and you just need to go through don't take the shortcut. Think these things through. Yes, they may be front-loaded, but there's going to be a payoff. If you follow the rules, the courts are going to respect that you did that, and you're going to move on. It's when you cut corners and you have high expectations on you that we start to see difficulties.
We've talked about a few issues so far that when you're in the fight, but there's also a few ways to avoid the fight and maybe to lift yourself up above the fight and get some sort of clarification or some sort of protection from the court or from other procedures available in the law. Judge Cowan and I are going to describe a few of those various solutions. Judge Cowan, if you tell us about the petition for instructions.
All right. One thing here is that what a petition for instructions, it's kind of a unique feature of the probate court. I was a civil lawyer, not a probate lawyer. And so to me, the whole concept of being able to come in to court and say, hey, judge, tell me what to do. It's a kind of a nice thing to be able to do. Take advantage of it. Okay? Eugene's going to talk about what needs to be in that petition, but basically the probate code sets things up so that you can say, listen, I don't know what to do here. I have conflicting demands. I have a client that's telling me one thing. I'm concerned about an appearance on issue in terms of ethically. The courts are open for business. We welcome these kind of questions. And but Eugene, how do we present them?
Well, one of the most important factors of a petition for instructions, and of course have your lawyer draft them, try not to draft them yourselves unless you are one, it's a complicated probate petition, is what the court, in my experience, generally does not want to see is for you to lay out 5 options and not express a preference. They want you to come in with what you suggest the course of action is, and you are the professionals. They rely on your opinions. So don't do a scattershot that, judge, these are the 15 different options, which one should I pick? That's not what the court's looking for. What the court is looking for is for you to give them a direction and give them some other options so they can tell you whether you're doing the right thing or you're not doing the right thing. And it provides you with an order at the end of the day that is your guaranteed protection. You've done what the court is telling you to do, and I don't think that any ethical organization overviewing your actions is going to say, no, you did the wrong thing. The court ordered you to do it, and one of your ethics rules say to follow all local rules, decisions, laws, so it's an important bit of protection. Another thing that's a very good and useful mechanism that many of you are probably familiar with is called a notice of proposed action. This is a tool that you use to notify either the beneficiaries of a trust or a probate estate of an intended action that you intend to take. And for certain things, you're required to give these notices of proposed action. And there's an interesting distinction that's very important to keep in mind between an estate and a trust when you're using this mechanism. For one, the notice period on an estate is 15 days as opposed to the 45 days that you have to give beneficiaries of a trust to either object or consent to your actions. But the other, even more important item is that if someone objects to a notice of proposed action in your estate, you must seek the court's confirmation in order to move forward. In a trust, and I say this with caution, move at your own peril, you can still proceed even in the face of an objection, but don't do it. It's not a good idea. Not a good idea. Go to court. The court is open for business, as Judge Cowan said. Go to court, get your orders, make sure that you're protected.
One thing we've been talking here about sort of general ethics rules and as for you as fiduciaries. But as you know, how you're acting as a fiduciary can differ depending on whether you're a conservator, trustee, executor, or personal representative. In other words, in a trust context, conservatorship context, or an estate context. And while it's probably common for many of you, and we appreciate that a lot of these, not everything ends up in court, and you want to keep things out of court, and often maybe in a more routine matter, it's not controversial to wear more than one hat and be both a trustee as well as an executor. You also need to think about, at least where there's an executor, there's an executor function, or even as a executor on a pour-over will, that you are in court vis-a-vis being executor, and the duties as executor may differ than your duties as trustee or duties as conservator. So while we're talking generally here about duties, I also want to kind of caution you that not every duty is the same, because who the duty is to may differ. And so I've had some matters recently where there's been an assumption wrongly that one can be both. Now, I'm not saying you cannot be both in many instances, but sometimes you cannot. So you need to think through who are the people who you're looking out for in an estate. Are they the same as they are in a trust? And they may not be. One prime example might be creditors of an estate to whom you may have duties as a personal representative of an estate in court. You might have different duties or no duties to a creditor as a trustee.
I think there's one other last solution I want you to comment on too, and I've done petitions for these. So, like I had a case with 4 siblings, and there were 3 850 petitions. You know, 850 where you sue to get money back. All the kids were cross-suing each other from stealing from mom. And I figured, this is pretty well litigated. I don't really think my trustee professional fiduciary needs to join this fight. So we actually brought a petition for non-involvement in litigation, and I set it out like, hey, everyone's already suing each other. Everyone's lawyered up. There's probably already $500,000 in attorney's fees. You don't really need us to join this. And I got an order saying, hey, trustee, you don't need to join. You can just sit there and be on the side and be neutral. What do you think about that solution?
Yeah, we do see those, and I've granted those. I think that every case is different. I think that's true with everything we do. But that being said, sometimes in the spirit of staying neutral, if it's really just, is A going to get the money or B is going to get the money, and it doesn't, the administration of the entity or the trust that you're looking after is not impacted, whether it goes to A or B, you probably may not need to be in that fight. That's kind of a simple statement, but because what the asset is, you may still need to be involved. But in a pure A versus B, the trustee may not really have a role. And so I think if at the end of the day, another important principle I haven't mentioned is that I like to think that I try to maximize the value of every estate in front of me. And so I want it I'm looking out for the person often who's dead, who has no control anymore about his or her estate. And so I want to be able to honor that person's wishes as much as possible and have that as much money as possible go to whoever he or she wanted the money to go to. And if we can reduce trustee expense in the administration of it, great.
As a kind of addition to what Lorianne and Judge Cowan are talking about, I've heard many new fiduciaries talk about how, I want to take private trusts. That's what I want to do. I don't want to do other things because they're easy. I don't have to go to court. I don't have to do any of those things. Well, let me tell you
Here we go.
that the worst case scenarios come from private trust beneficiaries. And I'm sure many of you have experienced it. I would urge new fiduciaries to really look hard at helping with more conservatorships. We need more people, at least in Southern California, to take difficult conservatorships. Don't expect to do the difficult ones right out front, but get your feet wet. Go and help. There is personal satisfaction in conservatorships that aren't necessarily there in trusts. So, Anyway, okay.
Time to start the fun part, right?
Yeah, now we get to start the fun part. So, all right. I'm going to read this statement regarding Superior Court. Hypothetical scenarios discussed in this presentation are for the educational purpose only. All of the parties in these fact patterns are fictional persons. Further, the Honorable David J. Cowan, Los Angeles Superior Court, do not endorse any of the conclusions or positions presented herein. All commentary from Judge Cowan is purely educational. Okay? Now we know why we never had a sitting judge before. Okay. I'm going to read the first hypothetical for you. 87-year-old Aunt B was married to Uncle Floyd for 60 years. She's been having a tough time after he died 5 years ago, and her dementia has now progressed to moderate dementia. She and Floyd never had kids, and all their siblings have predeceased them. But she does have 4 nieces and nephews, one of which married Joe, one of which is named Joe, who lives nearby. B and Floyd set up their Floyd B Trust in 2001. B was the sole successor trustee after Floyd died. But 1 year and 1 month ago, nephew Joe obtained 2 doctor's letters certifying that B is no longer able to handle her own financial affairs. Using those letters, Joe took over as successor trustee. He has also taken over as B's named agent under her health care and durable powers of attorney. The remainder beneficiaries of the Floyd B Trust are 20% to American Red Cross and 20% to each niece and nephew. Lorianne.
So this is what I like to call the fox guarding the hen house. When the surviving settlor loses capacity, who steps into her role to receive accountings and to oversee the trust? Well, that's the agent under the durable power of attorney. And it's pretty rare. I don't think I've, in fact, ever seen an estate plan where the same person wasn't named to all of them. Estate planners just do that. It's the same person who's always the first choice as the fiduciary, trustee, healthcare, durable power of attorney. So there's no checks and balances. And I find this leads to a lot of maybe conservatorships that could have been avoided if there had just been some sort of checks and balances, and we can get all theoretical and start talking about trust protectors. Oh, that's a good course for next year.
Yes.
You could have a trust protector who would receive accountings. You can start getting creative, but you guys are walking into the scene. The estate plan is what it is. You got to live with it. So I think it's a big problem without oversight, and usually cousin or it's nephew Joe isn't going to be the type who voluntarily sends the accountings to all the family members. That's what an upfront, transparent trustee would be, knowing that Aunt B's lost capacity. I'm just going to mail it to everyone. And that's the advice I give to people as a lawyer, even though if there may not be due the accounting, it's arguable the statute has started. And for me, representing fiduciaries, if I can get that statute of limitations for surcharge passed behind you, and then you can all breathe a deep sigh of relief, that's a good thing.
Yeah, I think, again, don't wear too many hats. Don't be greedy. I don't mean to be giving you a lecture, but I do see it where that people do take advantage of. I only see the worst cases, right? The ones that end up in court. But the worst cases are ones where people do wear too many hats. They see a wealthy family, and they milk it every way they can. And so don't do it. And again, I'm not trying to be high and mighty about this, but I think that we just see a lot of people doing that. And one easy way to not be caught up in that, or for it to be perceived that that's what you're doing, which is the same problem, because it's going to result in litigation, is to find a discrete function that you can do without controversy. The one further issue here is powers of attorney. They're common instruments that are legally permissible, but like any instrument, there's limits to them, particularly when a use of a power of attorney in estate planning context. It's one thing to have a power of attorney to perhaps write the mortgage every month, or to do routine day-to-day activities. But when you start having a power of attorney sign trusts, or to leave money to people, or to make significant gifts, I don't even need to comment. You know where I'm going, right? It's your conscience. You just don't do it. But people do it. They say, well, it's written there. I can do it. Well, you can't. Use your common sense. You all have it, and use it. And don't think you can get away with things, because when other people want that same pot of gold, they're going to fight you on it. And even if you win, what's it going to cost?
Lorraine, I have a question.
Sure. There should be a microphone, please.
I'll ask real loud. So I'm troubled with having to send out documents to the beneficiaries because of a duty of confidentiality. And so how I've avoided it, and I'm not sure sure if this is, oh, thank you. I haven't heard anybody else talk about this, but what I do, because I'm afraid of that part, what I've done is I've hired an attorney, either the one who drafted for my client, or if they're not available, then I hire an attorney for them and send them all my accountings or the documents in an effort to protect and hold myself accountable. Your thoughts?
Well, first of all, if you have an AB trust, and there's a lot out there still, even though we have portability, am I talking Greek yet? And you don't need an AB, there's still a lot out there. So if you are dealing with an irrevocable subtrust, and if it's a situation with a surviving settlor, you may actually have a duty to report to remainder beneficiaries. So first, you got to look at that. And what's fascinating to me is report versus accounting. You only account to the person who's entitled to the income, and that's not remainder beneficiaries most likely. Could be, read the trust, maybe not, but you still have to give them a report. And what is the difference between a report and an accounting? Who knows? But I'll tell you, as soon as a remainder beneficiary demands an accounting and you don't give one, they can go to court, and the court is going to order one. I think, I'll ask Judge Cowan, but in my opinion, judges are like, what's wrong with accounting? What's wrong with that? And I don't see a confidentiality concern when you're sending accountings to remainder beneficiaries. They're not strangers out there. So I'm less troubled by that.
Okay, so the fact would be this is a trustor who's been declared incompetent without capacity. So the trustor in this case is alive. So that was my concern. I'm not dealing with an AB trust. I'm dealing with just the trust. The trustor has now been declared without capacity. How do I hold myself accountable without compromising the confidentiality?
Is the trustor so diminished that she could not give you her wishes?
Correct.
Okay.
Honestly, in that case, my advice to the lawyer, because there is no oversight, unless there's a trust protector written in to receive accountings, I think it's so important to have someone overseeing the trust. Or if someone becomes suspicious of you and thinks you're not doing things right, they will find a way to go to court and get those accountings. So I personally am not so concerned about confidentiality. They're remainder beneficiaries. They're likely family members. I think especially as professional fiduciaries, you don't want to set yourself up as, no, you can't see the accountings. I'm the overlord. I don't think that's right. I think be as transparent as you can be as trustworthy as you can be, and I think you can't go wrong. And the upside is you've arguably started the statute of limitations. Otherwise, you're waiting for that surviving settlor to pass away to start the statute, and that's a long road. We like to shorten your road.
And just one thing to add, if it becomes a serious concern, use the court. You can file your accountings. You can seek the court's oversight. If you are really concerned about a situation, use the court and the protections that the court offers.
Okay. So we've got a twist on this hypo.
All right. So the twist on this is Joe's sister Alice from out of state goes to visit Joe and Aunt Bee. She notices Joe, who is a part-time golf pro, is now driving a brand new Range Rover. That's a lot of golf balls. Aunt Bee keeps talking about having no money, and Aunt Bee has a cast on her wrist. Aunt Bee says Joe tells her there is not enough money to pay for any caregivers to watch her. But Alice remembers that Uncle Floyd told her that he had about $3 million in their IRAs and investments before he died. Aunt Bee lets Alice look around the house for financial records, and Alice can't find anything. The house appears to have been cleared out of all records. Alice goes to the PFAC website, finds you, calls you, and asking what she should do to protect Aunt Bee. Things that seem fishy, and the things that seem fishy to her. So one of the questions is a conservatorship the best method to protect Aunt Bee? I would say it's the best method to protect Aunt Bee, but who's going to nominate you? Okay? Who's going to support you doing all this? Are you going to do it on your own? This came up in a class the other day that I was in. Are you going to do what I call the crapshoot? petitioning on your own, having your lawyer and yourself stick your neck out there, and maybe cost you some money to get it done. At our office, we've done that because we're about protecting people. That's what we do for a living, is protecting people. Not everybody wants to do that. Not everybody can do that. And if you're a new fiduciary, I don't recommend you do that because you have to know all of the ins and outs of it to do it. I would say it's the best method to do it.
Okay. So there are some considerations to talk about. The first one is the classic least restrictive means. And this is something that our judges have to think about with every conservatorship in front of them. Not every elderly person with a trust and a little family dysfunction needs a conservatorship. They're expensive. So it really does have to be no other solution is left. And, usually it's because there's been some elder financial abuse, that clearly the power of attorney route and the successor trustee route isn't working. So you always got to keep that in mind. And I keep that in mind when clients come to see me. I call this the red flags case. There are red flags all over the place, but no actual proof that something's gone wrong. And I think these are the toughest cases. The other thing to think about is the conservatorship of Ramirez's case, where the judge did what a lot of judges do, and they look out and they see families fighting, and they don't know who the good kid or the bad kid is. I'm just going to appoint a neutral fiduciary. I'm done with it. And that's what the judge did. But there had been a nomination of one of the kids when mom had been competent. And so what that case says is if the nomination of conservator was signed at the time the proposed conservatee could express an intelligent preference, whatever that means, as to who their conservator should be, you have to honor that. And what the code sections say is, so you honor that, but then the burden shifts to the other side to prove it's not in mom's best interest to appoint that nominee. And the court can't cut through that and I'm just going to appoint the neutral. You actually have to have a trial. I call these the mudslinging fights. And in my practice, these are the cases that are most likely to go to trial. Most everything else settles, but these fights are the worst. Who should be conservator for mom? Do you have any thoughts about that?
Well, just on the least restrictive means test, I think I want to throw out a curveball here we haven't talked about at all, which is elder abuse restraining orders. And this is an underutilized device that doesn't have the same powers and length that an effectiveness that a conservatorship might have, but has a lot less procedural issues to get there and can be done very easily on judicial counsel forms, often without an attorney, frankly. And if there's somebody who is stealing money, you can go in and get an elder abuse restraining order, whether you as the professional are the right person to do it. There's some issues there, but there may be a family member who can, and the standing to bring those, I think, as I recall, is pretty broad, and it's quite cheap to do it. You have expedited hearings on these, and you can put a stop to wrongdoing quickly. And so if there's just one distinct person, and that person can be ordered to stop doing that, and that's a solution, you should think about it. And it's really quite simple. There's pre-printed forms and quick hearings, so that's another option.
Who has standing to do that?
The elder themselves. If
Okay.
they're not conserved, it could be the agent too. Someone in a fiduciary role can bring
So
it.
if we were powers of attorney for...
You could do it.
Okay.
Yeah, speaking of quick, though, we just finished a TRO trial that was 7 days.
We have a question here.
Comment back to the last part of that info with the family coming in contact with somebody off the feedback website. I'm always very sensitive and careful about dispensing with practical versus legal advice and disclosing that I'm not an attorney and making sure. Oh, sorry. So I'll repeat myself there with the mic. Back to the hypo and the contact off the website there. I'm always very careful when being contacted to disclose that I'm not an attorney, that I can only dispense with practical versus legal advice and counseling, that they consult with an attorney.
Yeah, that's a good idea, yeah.
And it's one of your ethical rules to avoid doing that. So be very careful. Remember, with conservatorships, it's a last resort. There's constitutional law questions that come into play. You are literally taking away someone's right to make decisions for themselves, whether they be financial decisions or medical decisions. So the court is going to hold you to a very high standard to get these things done. You are literally stepping in the person's shoes, and everything that you can do to avoid it, you should try to do.
Frequently, when people call me about a family member that they feel needs to be conserved, I always say to them, let me refer you to a couple of attorneys, okay, so that they can help you go down that road, and then if you're interested, call us back. Julia?
Oh, there's a.
With Alice and Joe, could you?
This gentleman at the back, why don't we do him first, and then
Let's
we'll
do
come
it.
back to you.
Yes, I had a similar case as the Aunt B case, and basically what we did was we contacted the public guardian, and they're the ones that really took over the case instead of me spending money in terms of getting conservatorship. So the public guardian is very useful in terms of taking these type of cases.
Out of curiosity, what county are you in?
Los Angeles County.
Oh, wow.
Yeah.
Yeah, we just did that with Public Guardian on a case too, and referred it to them, and they jumped in and managed to.
Nice.
Having to deal with, do not exclusively rely on the public guardian. I know that they
Yeah.
they have an extremely high caseload and save the special cases for them. They're not equipped with taxpayer budgets to take on everything. They'd like to. They have great people working for them, county council. But I think that at least in Los Angeles, I know that they cannot. I'm surprised to hear the comment because they are just so overworked as it is.
Right. We're going to have one more question, and we have to move on. Julia?
And with Aunt B, if there is a possibility of $3 million, I wouldn't call the PG. But couldn't you maybe suggest to Alice that she demand an accounting from Joe first, because we don't have proof of his wrongdoing yet.
It's true.
And that could avoid a conservatorship.
But that goes back to his earlier question, where technically one isn't due to the remainder beneficiaries. And he
But
can
if
say,
she-
sorry.
But if she goes to court to demand one, she could get one.
She
is
doesn't
what
have
you said.
standing. She doesn't have
She's
standing.
a remainder beneficiary.
So it depends if we have an irrevocable trust. That is one comment I wanted to say about this fact pattern. This is why we end up with a lot of conservatorships. So the accountings are due to the person who has the power to revoke. Standing only exists for remainder beneficiaries if there's no one alive who holds the power to revoke. And keep in mind, the settlor, or little Aunt B, is not the only person who holds the power to revoke. Very often, that's included in the power of attorney. So it could be good old Joe's got the ability to revoke the trust, in which case it's still a revocable trust, and remainder beneficiaries do not have standing to bring a trust action. I have to bring a lot of conservatorships because everyone has a trust now, right? And there's no oversight. And I think it's a massive problem with the aging population. And the really only way to get your toehold on standing is to get a conservator appointed who then can step into Aunt B's shoes and bring the trust action. That happens a lot.
So is Noreen still neutral if she suggests that Alice could nominate Noreen?
I think a good fiduciary is not going to take sides in the beginning, no matter who nominates them. I think that's your job, and
Right.
that's what your ethics rules say. And I think I have a question for Judge Cowan. I think that'll be the last little twist on this hypo. So this is the classic red flags all over the place, but no direct proof of stealing. How much does it take, Your Honor? Let's say we're in front of you on a temporary conservatorship for Aunt B. I represent the Alice, and look at all these red flags. He's driving a Range Rover. I got a glossy printout of his Range Rover, but I got no actual proof. Are you going to order a conservatorship attempt when there is no actual proof of stealing, or how creative can you get?
Well, without answering the question, I'm going to just make I'll just comment that one thing that I often do in situations like this is kind of go back to where I came from in civil and issue injunctions as opposed to creating new animals, a conservatorship. and try to preserve the status quo and maintain things the way they are until I can have a full hearing and figure out what really is or isn't going on. I have learned something on the bench, which is that there's two sides to every story. And I try to keep remembering that because it's very easy too easy to be persuaded by somebody who seems very earnest and begging and looking at you to ask you to do something. And they may be all of those things, but somebody else may be more shy about wanting those same things. So we do try to only make decisions after we've heard all the facts. But at the same time, we have a lot of vehicles such as injunctions to keep the status quo and prevent things from getting worse, but without necessarily creating new problems. So that would be kind of sort of a general response. And I think the other thing is that I do sometimes see a lot of professionals and others come in on an initial hearing and expect us to do magic, which you may have seen last night, but you will not see in a courtroom. And it's very difficult, if not impossible, to, in a 10 or 15 minutes in a crowded calendar, to figure out what happened. But you all come to court, understandably, wanting us to figure things out that morning. But you need to talk to your clients and make sure they understand that court is a long-term process, and for good reason. You don't want us making decisions in 15 minutes, 10 minutes, 5 minutes. You want us to do it after hearing all the facts. So keep in mind what the expectations of your clients in terms of how long the court process is. People often think of that as a complaint. Oh, court takes forever. Well, there's reasons for it sometimes, particularly in these kinds of cases.
One of the, I'll take one more question, but I want to say something first. One of the cases we recently got, one of the judges in Los Angeles, Judge Green, got very creative with us. She allowed us to be temporary conservators of the estate with limited powers to investigate investments, money, because we were afraid her money was being taken. It was very effective. It went, we had to go back 2 or 3 times, and she allowed us more and more and more. So we investigated. We're now temporary, and we will be permanent down the line. So it's another choice they have. One more question, and we'll move on.
So one remedy I thought might be good to mention here is if somebody already has a durable power of attorney, they have the advanced self-directive, they have the living trust, why can't the court just appoint somebody? Why can't the court just appoint somebody temporarily to step in that role if they think whoever's not doing a good job? Instead of, that way we can avoid a conservatorship. They appoint a private professional instead to take over, and maybe even appoint a guardian ad litem to kind of look at the matter, and then if it's not needed, they can put the original people back in place, and then we minimize the need for a conservatorship. Also, in this case here, wouldn't APS be contacted first? Because if somebody calls me and tells me all this stuff, the first thing I got to do is I'm put into a position, if they tell me the name of the client, I have to file an APS report.
One of Noreen just asked me to ask you what county you're in, because not every county can move quickly with APS. In Los Angeles, for instance, APS gets a lot of case referrals, and it's difficult for them to move quickly. And oftentimes, when you have an issue of financial abuse versus physical abuse, they have a difficult time sorting out the mess because you have to look at records, you have to try to figure things out, and sometimes it's not quite as clear. But the solution that you discussed with the temporary appointments is one that's often used in Southern California, because a permanent conservatorship, you may not just have the children fighting, you may have the individual themselves not wanting to be conserved. So as we talked about, this is a very important process, and the constitutional rights of the conservatee have to come first. The idea of crafting some sort of a temporary solution or coming up with ways to preserve the status quo is the best way to take your initial steps forward. Otherwise, you might be dragged out into a 9-month, 1-year, 2-year proceeding before you can sort out anything in the mess.
Another important professional for us in probate is the court-appointed lawyers. In Los Angeles, I don't know if it's in every county, probate volunteer panel lawyers who are appointed by the court in conservatorship cases. And though that's not appointing a new person to put in charge, that person can often give us some good impartial information that sometimes will have us do something, put somebody in temporarily. But I think that at least in the conservatorship context, we are constrained appropriately in putting other people in charge of other people's rights, unless there's some very good reason. And I think that judges sometimes come from a criminal court background, and a very naturally, or any background, but particularly there, but who are concerned about taking away people's rights. And of course, with the elderly, we also want to make sure that people's rights, they get to keep their rights, and even when sometimes it's hard to hold on to them. So I think there's some varying kind of competing goals here as well.
Well, there's one other thing. There's no statutory authority for a court to appoint another agent under a power of attorney. The power of attorney law, there is one in the code. It's underutilized. It does give the court the power to suspend, but they can't appoint someone else. That's why we have conservatorships. It's the alternative. So I wanted to point that out. In your question, the only role that the court would have authority to appoint a successor to would be the trustee. But you got to find someone with trust standing, which can be, an issue for a trust that's still revocable. So I think, are we ready for the
Yeah,
next
we're
typo?
ready, Your Honor.
There's yours.
All right, very good. All right, an attorney named Letty Gator caused you to ask if you could serve as a conservator on a case she is going to file. She confides in you that she normally does not take probate court cases. The proposed conservatee has 2 adult children. Ms. Gator says her client is the daughter of the proposed conservatee, who will be the petitioner, and they think the son is going to object, seeking his own appointment. Ms. Gator tells you she wants to be your attorney as conservator if successful in getting you appointed.
Okay. So, we have 2 really bad decisions, 2 really negative things here. My response was just say no. First of all, hiring an attorney to represent you that knows nothing about probate's not a good choice. I don't know how, and maybe the attorneys can say how the bar ethics allow her to represent this person and then to represent us too. So it's a very simple discussion for me. I just would say no, and our ethic rules also support conflicts of interest. Even if it's the conflict of interest of the attorney, we don't want to be involved in it. So.
And the answer is straightforwardly no. We could not represent both people. It's a simple answer for the attorneys. The answer is no. We could not represent both parties when there's such a clear potential conflict of interest, because maybe they agree for now, but if the moment they disagree, you'd have to withdraw from representing both.
Also, the other issue here is her being not knowing probate. I don't know how many of you have the opportunity to go to court and how often, but when we had the recession downturn, it seemed like every attorney in the world decided they wanted to get into probate. And I used to sit in the audience and I used to hear them, and it's usually family members they end up representing because I think we would be smarter about it than them. And I sit there and I want to say, oh, please, let me find you a good attorney, And I'm sure the judiciary would appreciate a good attorney too. Because, people, this is a very complex process, and family members just want to get through it and want to get out of it. But not an attorney who's new to this business, doesn't know it, don't go there.
One of the things that this issue raised, the issue that occurs to me and this hypo is a little different, and it will be in this and some of the other ones that we're going to talk about coming up, is the whole concept of unstated understandings that may exist between yourselves and lawyers, or hopefully does not exist between yourselves and lawyers. And it's one that's difficult for the courts sometimes to know if they do or don't exist. But I think that we all know it happens, right? That people make promises, implicit promises to one another, for future business. I'd be naive to think that that does not exist. And so you need to think through, as we kind of talked about at the beginning, are you implicitly, even with looking somebody in the eye, do we have some understanding that nobody else knows about? You got to be really careful about that, because they may think that you have that understanding. Maybe you didn't have that understanding, but we all know how some people do business, and so you just got to think through and make clear what it is you're going to do, what it is you're not going to do, and make sure that, as we all also know, sometimes relationships go south, and people are not able to keep these promises, or that maybe should never have been made. What are they going to do when their expectations change? So again, I don't have the answers to these kind of questions, but I'm aware that I think that some of these hypos are interesting to me because they kind of approach that area. I don't know if anybody of you, your experiences as lawyers, it might be helpful for this audience to know about.
I know one thing when we were discussing the slides is, for example, I love Noreen Bomer. She's a tough fiduciary, and it just so happens I've never represented her, and it turns out to be good because when I represent family members, there's no conflict. So, I can't represent every fiduciary in the world and take private clients, or I'd never have a conflicted free fiduciary to nominate. But then I remember you, Your Honor, saying, well, if you nominate Noreen on all your cases, isn't that some sort of unspoken preference? And is that neutral or fair? And it did get me thinking, you got to spread the wealth, right? Maybe? What do you think, Noreen?
Well, obviously we like working with Lorianne because we understand each other and stuff. I think you need to be careful. Actually, the discussion that started this whole neutrality was between Lorianne and I, and it was about a case that she had referred to us, and the family member, the petition was to appoint us as conservator of the person in the estate, and there was an error that the judge didn't understand or something, and he appointed the family member conservator of the person, appointed us conservator of the estate. So, and Lorianne's clients went out to see their mother at where she was with the other part of the family, and they wouldn't let her in. So Lorianne says to me, well, I need you to go with them. I said, I can't go with them. I'm neutral. I'm not going out there. You're out of your mind. So that's if you have that kind of understanding, and obviously we like getting cases, but if it felt to me like it wasn't good, and I'm sure Lorianne would feel the same way, how it feels to you kind of thing, we would all go away. We would back out of it. We would do whatever it took to make it okay.
And as you can see, Noreen has no problem saying no to me.
The idea is we're discussing ethics here as well, and whether you fight or you don't fight and what you do here is all managed by your ethical rules. If you stand up in court and you do the right thing, I don't think there's going to be a perception of a conflict, especially if everyone is representing their clients, their prospective wards or conservatees or beneficiaries in the right way. Good people are recognizable, and it's easy to see when you're doing the right thing for the right client. So that perception may be there if you have cases where you frequently work together, but at least even in the biggest probate department in the country, like Los Angeles, there are very few people who could take on tough cases where experienced fiduciaries are needed, and the same is true of their counsel. You can't really walk into something like this without having some experience and knowledge. So try to avoid every conflict you can. Try to make sure that you spread the wealth, as Lorianne says, but at the same time, just make sure that you're carefully fulfilling your duties on every case, and I don't really think you should have a problem.
Okay.
You read the next one?
All right, let's go on.
All right, so we're moving on to our next hypo. Your favorite attorney to use on messy, contested cases is John Verbosity. You have around 7 to 8 cases with John right now. It's Friday at 5:30 p.m. at the office when John calls you, and he's got a great case for you. It's a trust case with assets of $20 million, no court supervision, and 4 litigious dueling sibling beneficiaries. It's the best, right? Of course, you say that that's fantastic, John. Can you represent me on this case? You're used to John, obviously. And John says, well, let me think about that. I already represent one of the sibling beneficiaries on this case. So we've been talking about these questions already. So what should you do? And when you and John talk, should you agree to his representation, or can you accept this case yourself?
No, again, it's a clear conflict to me for me to be on a case. Let's assume somebody else called me on this case, and John was represented one of the other people. I probably wouldn't take it then because he represents me in other cases. It's very interesting that John would call me for this, given the other cases he works with me on, and he knows how sensitive I am to ethics. But he is John Verbosity, so anyway.
But again, what would let's just say, is he effectively asking for some commitment on your part? Let's just say you did take the case. I know you said you wouldn't.
Yeah.
But is this the same situation or a similar situation to what I'm just alluded to before, in the sense that that you're going to go light on his client if you are the conservator?
Well,
it's a slightly different question.
right. I don't know anybody who would know me in my office that we would go light on anybody. But I mean, our attorneys work.
I'm just saying generally, obviously not
Yeah,
you.
yeah. I just wouldn't take the case. I would never have that agreement with anybody because.
Well, do you, as the lawyers, then do you have concerns about if you saw a trustee or fiduciary who has a pre-existing relationship with an attorney on other matters, and now is in a contested matter, not with the same attorney representing a beneficiary, what are you going to do about that?
I've seen it. It happens. And as big as LA is, our bar is relatively small. There's only so many fiduciaries. There's only so many good lawyers, and I've seen it. What else? So, do you have any thoughts, Eugene?
From the perspective, you're going to give the perspective of a litigator. There's a lot of, typically when I'm in this situation, if I'm John Verbosity here, I would be representing the settlor on this situation. Mm-hmm. This would be my estate planning client, and if there's a particularly big problem, you may consider having someone else appointed, doing an amendment to put a professional in place. More often than not, this is going to come from the perspective of one of the children. And like in this situation where John represents one of them, our ethical duties are strict as well. This is a potential conflict, and there's so many different ways that this could go wrong for you. The idea of having one of your regular clients work on this case, along with you working on this case, is a bad idea as far as I'm concerned. But fortunately, there are other attorneys that you may know, or other attorneys that you've heard of, that would be decent representation for your professional fiduciary client. And spread the wealth. Give them the case. Don't try to keep everything, because this is where you end up in a really bad situation potentially down the line. And there are those unspoken agreements at times that I've given you this case, you better take care of my people. And you don't want to be in a position where you're being perceived as having a conflict, because remember, in your rules, even the mere perception alone is enough to be an unethical undertaking.
I think there's a lady at the back who wants to add a question.
Yeah, BJ?
I think while we're waiting for the mic, it's for us lawyers, there's a distinction between a potential conflict and an actual conflict. And we're not out of the case until there's an actual conflict. Potential's not enough, but it should be enough to get the hairs on the back of your neck going. And I think it's important in that situation, even if you're not going to represent the professional fiduciary in that particular case, but you represent them on other cases. And look, sometimes you got to talk a fiduciary into a case. And they'll only consider it because you're like, come on, you've done other cases for me. Someone's got to take this one. It's important that you disclose to all the parties, because your worst nightmare is the day where a matter where you represent that fiduciary is called, and two matters later is the case where you're now the lawyer on the other side. And what do those family members think when they see that? So you've got to disclose and be as upfront as possible. And as lawyers, sometimes we have to get written waivers of conflicts in those situations. So.
I was just going to say that I think that an important aspect of this is disclosure. In some markets or some types of cases, there are just not a lot of qualified people who can take it. And also you have the PVP panel. And so there are a lot of different situations that you would have been opposite or interacted with an attorney. I would also say in this case that I would never have the attorney to represent me and one of the family members, but I would also have counsel, all right? So I don't think that it's necessarily unethical for me to take the case if there's disclosure and if I'm represented by counsel that is not, representing anyone else involved in the case.
I agree, but at some point, if that attorney who's represented you in other cases, his client wants to go after you and surcharge you, he does have to get out of the case, because now that potential for conflict has become an actual conflict. And he can't oppose you in one case and be on your side in another. It's something called the duty of loyalty. We're supposed to be loyal to our clients.
And think about how important, I'm sorry, Judge Cohen, think about how important that could be, especially if you have 10, 15, 20 cases with this individual, and now you're on opposite sides of a case because you're being surcharged. So the consequences could be a lot larger than that one individual case.
Just going to say, somebody brought up the concept of waivers of a conflict of interest. And they're certainly out there in the lawyer context, and maybe they exist for fiduciaries as well, but I wouldn't necessarily bank on all of them. And you can have a nicely written one, and maybe it'll work, maybe it won't work. And it's who is the person who's waiving these rights? Does he or she understand what they're doing? I bet I sometimes don't understand these documents when I'm reading them. So is your elderly, non-educated client understanding what he or she is doing when you ask them to waive the fact that you also have an attorney? Have they thought through all these permutations that we're discussing? Probably not. And so, again, be real here about what it is you're having your client sign. Is some judge really going to buy off on it, right? We're not going to just take the printed word and just, it's the end of the story. I think it's fair to say. So, again, don't expect more than is reasonable.
And one quick point, I don't think that professional fiduciaries can waive conflicts of interest. I looked at your ethics rules. I didn't see that anywhere in them. Perhaps there's some case laws out there that says that you can. In our research on this presentation, I didn't come up with that answer anywhere. So be very careful. There is maybe something out there that we just aren't aware of, but I would caution you.
The appearance of a conflict.
It does. The appearance of a conflict itself is enough. So be very, very cautious. Your attorney may be able to waive their conflict of interest, but I don't think you can waive yours.
All right, we're moving on to a new hypo now. Connie's 1999 trust originally named her two daughters as remainder beneficiaries of her $8.5 million trust estate. 2000, Connie added gifts of $500,000 each to a caregiver and a friend. 2004, she restated her trust to leave a large gift of real estate to her gardener and 6 other residual beneficiaries, including the gardener and 5 other friends and caregivers. 2005, another restatement is made, this one leaving just $500,000 each to her 2 daughters, i.e. removing them as residual beneficiaries and naming 7 residual beneficiaries and another gardener as to 1/4 and 1/8 as to each to friends and caregivers. The 2005 restatement significantly named a professional fiduciary as trustee. One of Connie's daughters, not surprisingly, contests the trust. For the last 2005 document, Connie saw neuropsychologist who opined she had capacity. Connie also got 6 certificates of independent review for each of the residuary gifts from an independent estate planning lawyer. The 2005 trust has a strict no contest clause. I'm not going to read it all, which states if you attack or defend or the expense of a trust, there may be a forfeiture. You are the professional fiduciary named as successor trustee. You give the required notice to beneficiaries. 2 daughters then file a trust contest. Then Gardner's attorneys demand that you defend the trust contest as trustee using trust monies. Noreen?
I didn't know Georges were so torturous. Wow. Yeah, I'm at a loss for words, Your Honor. I would.
Well, pass it to Eugene.
Yeah,
Eugene's
make
got a
him-
big reveal
make
on
him do
this
it.
one.
So one of the most interesting things about this hypothetical, and I know we caution that none of these are real cases, but this is actually a published case. This is the Doolittle case, and it's, believe it or not, it's a scenario that Judge Cowan described as pretty much the scenario that happened in the case. One of the most important aspects of the no contest clause is that it directed, without any kind of maze, a shall to defend any kind of contest against the attacks on the trust. And this was an order to the trustee to proceed in this way. So the question was whether, one of the questions is, well, can you avoid defending the contest? Should you agree to do it? There's a few probate code sections that are directly on point that need to be discussed first. One of them is probate code section 16,000, and that tells you that you must administer a trust according to its terms. That means follow the language of the trust directly. Another important probate code section implicated by this scenario is probate code section 16003, and that says that you have to be impartial to all beneficiaries of a trust. That means that this is the neutrality part of what we're discussing. Everyone deserves your neutrality, and every beneficiary must be treated equally. And there are certain other provisions in the probate code, 16200 is one of them, that allow you to proceed along the lines of what the trust tells you to do and to not seek any additional powers than are what are there in the trust for you. You have all the tools that you need by the terms of the trust and by the probate code to proceed with the defense of this trust, and ultimately the trustee in this case was required to defend the trust. The contest had to be defended. So there's a few ethics rules implied, and I think that this is a case that Lorianne loves, so I'm going to switch over to her and allow her to continue the discussion here.
As a litigator on the panel, this is my new favorite case, Doolittle. So practically speaking, whoever has the litigation war chest can change the game on the case. And if you take the litigation war chest away from one of the parties, I don't know why, but when lawyers don't get paid, the case settles. It's crazy. I don't know why that happens. So Doolittle's fascinating to me because it applies to every single trust contest. I've been doing a dog and pony show for another speech to lawyers, and I tell them all, go back to your office every single trust contest, and same for all of you. You need to look up the no contest clause and see if it includes this instruction. It could just be one sentence, and it changes everything. So Doolittle starts with the basics. You fiduciaries in trust cases have to be neutral. You can't take sides between the beneficiaries. And you would think that's what the beneficiaries would expect. You owe duties to all of them, not one over the other. But if this instruction is in the trust, all bets are off. You have to take a side. You do not have a choice. You do. And so it was a bank, Exchange Bank in this case, who actually had to pony up. They did a petition for instructions because, like, oh my goodness, banks aren't used to taking sides. And they brought a petition for instructions, and the court said, yes, you need to defend the contest. Can you imagine? I mean, how many of you have ever actually defended a trust contest as a fiduciary? Wow. Hey, we got a couple, just a few hands. It's amazing. So this case is out there to make it very clear you have to, if that instruction is there. And you can imagine in this case, the gardener, who I'm not making this up, his name was Juan the gardener. He wanted that trustee to defend it for him because the trustee has the litigation war chest and they could just crush the other side. It's a game changer. So it's just crazy, eye-opening new case. The other thing that's fascinating is if you have an older trust that maybe doesn't have this language, then you can't take a side. But in a trust contest, the trustee has to be named as a party. It's just sort of this weird legal standing requirement. So keep in mind, you may get served with this contest, and as trustee, you've been named as a party. It doesn't mean you can do anything. You've got to go straight to the trust, huddle up with your lawyer, and see, well, okay, what do I do? What does this trust say? And it could be that instruction, maybe it's not in the no contest clause. You've all seen these trusts. It could be 50 pages single spaced. It could be buried in there. So some careful consideration is taken. I think it's kind of fascinating that you may be in the position where you're named as a party to a contest, but your hands are tied. You can't defend. I think you're going to have to write the beneficiaries like, hey, I've been named, but there's no instruction for me to defend. I have to be neutral. You all need to lawyer up and handle this and put them on notice. The other fun thing about Doolittle, and I think the judge had brought this up earlier, the equitable powers of the court. So what if the trustee has the litigation war chest, he's been instructed to defend, and let's say, in this case in Doolittle, the mother really did not want her daughters to get her money. She really did want the caregivers and the gardeners to get her money. And it's a poster case for how to do this right. I mean, she went to the neuropsychologist. She went to independent attorneys. I mean, this thing was as buttoned up as you could be. I think this also points out how easy it is to be judgmental. You hear the fact pattern, you think, oh, bad gardener, bad caregivers. Maybe not so. Don't jump to conclusions, right? So what's the solution? If this really was a case where it was a unduly influencing gardener and this, mom had lacked capacity of some kind and there was no neuropsychologist or independent certificates, if you didn't have that situation, the other side does have the ability to go to court and get an injunction. And I can legal out on you with attachments and things like that. But there are some remedies in litigation where early on in the case, you can say, hey, judge, they don't have much chance of winning this. I can prove that I got a pretty good shot of winning this thing, that Juan the gardener's a really bad guy. And you can get an injunction to stop the trustee from doing the defense because he doesn't have a very good shot at winning. And that's going to change the game when Juan the gardener has to hire his own attorney. And he hasn't received his distribution yet, and he's got no money. Maybe he'll find a contingency lawyer. But it really settles down the litigation, calms everybody. So I think this is a fascinating case. This partly is what inspired the talk, too, is we actually now have a case that's very clear that says in black and white, trustees are to be neutral, unless it says otherwise.
And a small word of warning, most modern trusts have provisions that are similar to this in the no contest clause. So read your trust carefully, but a lot of the estate planning software that estate planners use have these specific no contest clauses in them now. So you're going to be seeing them more and more, especially with trusts that are drafted in the last 5 years and going forward.
The other thing that I kind of have a different reading on this hypo, which is that Lorianne indicated, well, if it's all buttoned up, we have 6 certificates of independent review. My inference from that is it's not all buttoned up, because if there were 6 certificates of independent review needed, something is not right. I mean, you can go too far, right? I mean, so that would raise my eyebrow that if somebody felt that much need for so many doctors, something's not going on. So likewise, attorneys, doctors, they're not necessarily the last word either. It wouldn't be the first time a doctor said something because they were paid to say something. No offense to doctors, but it happens. And they can reach wrong judgments just like courts can make wrong decisions or lawyers can make bad decisions or otherwise. So we're going to scrutinize everybody, not just gardeners.
I want to see the accounting on the distributions. I mean, there are so many different percentages in this. The distributions must have been nuts.
It may, but don't judge a book by its cover all the time. It's there. There really are certain situations where family members, or the person in place here, didn't have a close family member. The kids don't speak anymore, but they rely solely on those people who are around them, and that's the reason that these certificates of independent review were designed, to make sure that the gifts to what are prohibited classes of beneficiaries, sometimes those are legitimate gifts, and sometimes the only way really to figure this out would be to put the certificate together to get this geriatric evaluation, because as you can see, it smells bad. And a lawyer out there who sees this, who has one or maybe one of the other family members who got disinherited come in, says, of course I'll take this case. Look at all the beneficiaries of this trust. Look at how over the top that they went to try to protect this instrument. Something is fishy here, but these procedures are put in place for a reason, and these things are supposed to button up a trust.
In actual fact, did she keep going to the same attorney, all those different amendments, or was she going to different ones? And I'm going to ask, Judge, would you feel differently look at if she kept going to different attorneys rather than her longtime attorney? Would that tell you something?
I believe the 6 certificates were done based on the 6 different residuary gifts to prohibited individuals. So there was a certificate done for each prohibited gift. I don't know if it was all the same attorney or not, but it was.
Would that be meaningful to the court?
Well, I think that if a number of different people who, well, I talked about scrutiny, that doesn't mean I'm not going to give deference to people sometimes who I otherwise know would be entitled to that to some degree. And if I see 6 people who have no reason for me to believe that they would do something unethical, it would lend to, I suppose, to the conclusion that it is okay. I mean, but every case is different. But I mean, I think that if you've got one lawyer doing it, it might be more suspect than if you've got a bunch of different people all reaching the same conclusion.
Should we do the next hypo?
Yeah.
Yep. Okay, so hypo number 5. You get a call from Tammy Estate Planneroff. I wanted to make sure we had names of all potential ethnicities. An estate planning attorney you have known for several years. Tammy tells you she has a wealthy estate planning client named Sally, who doesn't trust either of her children to act as trustee after she dies. Both have financial problems and a history of conflict with one another. Tammy has convinced Sally to name a professional fiduciary as successor trustee and thinks you'd be perfect for the job. Tammy wants to send you a consent to sign. In passing, Tammy tells you that Sally wants to leave the substantial majority of her trust to the good daughter. She has recently come back into Sally's life and is calling her regularly. Sally believes this may be a problem when the bad daughter finds out about the distribution plan. And there's a lot of questions here. I'll let you all work through them
Okay.
as you go.
So the first question, or the first issue I see is, I want to see what your trust says before I agree to anything. And then I call up Mr. Eugene here, and I say, would you please read this? This person wants us to be trustee. Do you see any pitfalls? Give him the information that Tammy has given me. And if it seems, okay, and he says to me, it seems okay, just the knowledge that she wants to leave, I don't see a problem as a fiduciary just with the knowledge that she's going to want to leave her money to, one of her daughters, good, bad, or indifferent. Because if that's what her wishes are as trustee, you carry out her wishes. So I don't see a huge issue there around that. Now, that doesn't mean, do we end up in court and litigation? Oh yeah, sure. But it doesn't mean you can't take the case.
One of the things that is often the case is, and we'll see this more on the twist of this hypo, is that the good daughter can often become the bad daughter, and that can change over time, going back and forth. As an estate planner, one of the things that is critical is to make sure that you're trying to honor the wishes of your client and make sure that whatever gifts they want to give, whether it be something that you may tell them may change down the line, to try to put mechanisms in place to do it. So when Noreen calls me, I might make a few suggestions to her that she may refer back to Tammy. And Doolittle talks about a few of those key points: getting certificates of independent review, making sure that people get evaluated. And I know estate planners who make sure that they get an evaluation for everybody past a certain age, just to make sure that their document's integrity is protected. It might be overkill for smaller estates and for people who can't afford those kinds of efforts, but at the same time, as someone who produces a work product, you want to make sure that that work product is protected and that work product stands up. Otherwise, you're doing a disservice to your client, as far as I'm concerned. And I think that if we bring together some of the secondary issues that arise on the next slide, because we're running a little bit short on time, so I want to move us forward a little bit.
Just make one quick point that one of the things that people say about lawyers who've had their own practices over the years, the people who are able to do well, and I think the same rule would apply to fiduciaries, is to, do you really want this person as your client? And you can have as many protections as you want built into them, but at the end of the day, do you trust this person who you're going to be acting for? And so you need to have hard conversations with your clients, whether you're a lawyer or a fiduciary, about is this who you want to be working with going forward? And so I think, again, as part of your ethical duties, it seems to me you want to have a good conversation about what are all these facts going on out there. You want to have a good initial discussion about so you don't find out things later once you're already doing things for this client. So again, I think people would often say you've had a successful practice when you've told people, no, I don't want to be your advisor, whether it's as a lawyer or a fiduciary. And so everybody is entitled to a lawyer. Everybody's entitled, I suppose, to a fiduciary. But query: should it be you?
You ready for the twist? Oh, we had a question. You want to take the question?
Yes.
Sure.
We have a few.
So I'd like somebody just to talk about this issue of signing consents. I tend to avoid signing them until I'm actively going to work in the case. Many times I've been asked, because attorneys seem to include them in the trust or the power of attorney documents, and I don't want to sign them when the person is clearly not going to need me for who knows how long.
That's a very good point, and oftentimes, at least from the experience in my practice, I really won't have someone sign a consent if they're going to be acting. Typically, it's going to be a secondary trustee, and the settlor will still be hopefully able to manage their assets, or I shouldn't be signing a trust with them on that spot at the time. Of course, there is some distinction between being able to manage assets and having the capacity to create estate planning documents, but that's a technical distinction we won't get into here. The idea of signing a consent too far in the future, you're right, is it could be a very imprudent move because you don't know how circumstances are going to change, what the state of the trust or the power of attorney estate is going to be when you actually come into the estate. So, being appointed as a successor trustee and maybe accepting the ultimate appointment, that's a more prudent move for something that's a little further down the line.
One
And,
more.
and just to piggyback, but I would prefer to know that Tammy had not just suggested me to Sally. I would prefer to know that Tammy had given a list or perhaps three people's names and let Sally decide who she wanted. I just think it would be avoiding conflict later on if you were the only one she talked to.
That's very wise of you to say that, and it kind of dovetails into some of the rules of the certificates of independent review. when you have an attorney who's reviewing a document, they have to be independent. So the idea of referring everything to one attorney or to referring everything directly to a specific person, whether it's not just one or two or three that you have a relationship with, some court decisions have signaled that that would make that reviewing attorney not an independent individual. And I would encourage you to do the same, to encourage people to have more than one fiduciary appointed, or to refer them to the PFAC website directly so they can look up somebody who they can have, one, a good personality match with, but two, some variety so it doesn't look like you're in cahoots.
Okay, now we're ready for the twist. Let's just
The
twist
twist
it.
may-
Come
yeah.
see us later. The twists are fun. Now suppose that Tammy wants to name you as a alternate successor trustee to serve after the good daughter. You agree after reviewing the trust. Sally dies, and Tammy now represents the good daughter. This happens a lot, right? The estate planner now represents the trustee. As Sally predicted, after 1 year of inactivity in the trust, the bad daughter files a petition to remove good daughter for breaching her fiduciary duties. Before the first hearing on the petition, Tammy contacts you and explains the situation. Tammy states that her client is willing to resign and reminds you that she recommended you for appointment as successor trustee. The language of the trust does not require you to investigate the actions of the previous trustee. The language of the trust also absolves you of liability for failing to investigate and prosecute the previous trustee of wrongdoing. Bad daughter contacts you and provides you with several documents that actually do prove good daughter did in fact take monies from the trust she shouldn't have. What do you do, Noreen, Eugene?
There's a few clear answers here that you have to really think about, and your ethics rules are the first place to look. What you're looking at this scenario, and you have a couple of things that have to be going through your head right away. Tammy is a good referral source. She reminded you that she's the one who brought you into this case. That has to be spinning in the back of your mind. It shouldn't be anything that guides your ethical duties, but we're human beings, and obviously that's something that you're going to be thinking about. The probate code requires you to administer a trust according to its terms. We talked about that earlier, and it looks like you're absolved of any liability here for not going after the previous trustee. In fact, the general rule is that the successor is not liable for their actions of the predecessor. That is the standard approach for any of these kinds of situations, but there's a caveat to it. There's a catch. The catch is, and this scenario points it out very nicely, that if you have actual evidence of wrongdoing, you could be personally liable for not pursuing the previous trustee. Now, even though the trust absolves you of this liability, it doesn't matter. It doesn't matter. If you have the actual evidence in your hands that something has gone wrong, you have a legal duty to pursue it, and you have an ethical duty to pursue it, because you, by your rules of ethics, you have to go forward and you have to pursue every claim that's owed to the trust. We often overthink this issue, and we look at the document itself and we say, you know, this is the end-all be-all. You have the trust. This is the entity that's controlling everything. These are the rules that I have to live by. But there's other rules that supersede those rules, and make sure that you protect yourselves from liability. Call your lawyers. Their job is to protect you. Seek the right advice and make sure that you understand who you have to be loyal to. It's not Tammy. It's not the good daughter who's now the bad daughter. And it's not the bad daughter alone as well. Your duty is to protect the whole class of beneficiaries here, and your duty is to make the trust whole when you see a scenario that comes into play.
So the other issue, probably from a practical standpoint, what I would do is I would say I need to see an accounting from the prior trustee. That's the first thing I'd want to see before I agree, because as you may or may not know, you could just refuse to serve. You don't have to worry about it. And the other issue would then be, Tammy, I'm not agreeing to not investigate the prior person. So if you still want me, great. If you don't want me, fine.
Quick question. Are there do you see any legal or ethical duties that one might have even before accepting the office?
I think in this scenario, you've already accepted be naming you were named a successor trustee, and now some time has passed where the original client has died. You're right. The best thing to do might be to resign right there on the spot.
Would you still have any legal or ethical duties beyond that?
If you were to receive that information prior to your resignation, it just depends on timing. You don't have any ethical duties until you're actually acting in any role. Your ethics rules apply only when you're actively acting in a role. So you look to the different sections of the ethics rules for fiduciaries, they apply to very specific scenarios. And remember one very important thing here. Lori Ann touched on this earlier with the Moeller case, and that the office of the trustee holds the right to transfer of Tammy's file. So if there's anything in there in Tammy's file that may be damning to good daughter, that's going to pass on to you as well. And that may force your hand.
So we do have, we are mandated reporters in certain scenarios, and there's nothing here necessarily falls into that, but there could be a twist in there as well.
You're absolutely right.
Okay, so we only have 5 minutes.
May I
going to
make
say
a-
that
May I make a comment real quick? I'm chair of the Fiduciary Academy. When you opt not to take the mic, you're saying to your colleagues the next 2 to 3 years that your question wasn't important and we couldn't get it on the video. So please use the mic. Thank you.
Okay.
just going to say about looking at documents that purport to absolve people of liability. Documents don't absolve you of liability. Courts do. So the documents only, that's just a document. It's not a court order.
It's very true.
Do you want to do the last twist? You want to twist again? Okay, let's twist again. After speaking with Tammy, you agree to serve as successor trustee. You were also named as executor in the pour-over will. Upon doing a bit of research, you determined that Sally had a bunch of children with her previous husband you didn't know about. Huh. You called Tammy with the news, and Sally, well, says she's sorry. I forgot to mention it. Tammy also tells you she believes Sally funded her trust with assets which were the community property of Sally and that first husband, previously held by their joint trust. You also discover that Sally transferred a $600,000 investment account into her trust. Never transferred the $600,000 into her trust. So now we've got something we may need to probate or do a Hegstad. You review the will. You're named as executor. The will states that she gives a gift of all her assets to the trust. You file a petition for probate. A week before the hearing, you get served with a competing petition for probate. It attaches a codicil which removes you as executor and names one of Sally's children from her current marriage as executor. This is yours.
Go for it. When do you start on it?
Okay, Judge Cowan.
So here's the thing. There's actual case law on this. So here's what the case law says. So you're named as executor. So usually if you're named as executor, you do have the ability and the standing to step in and fight a contest, because this could develop into a will contest, right? But the exception to that is when the only change between the will and the two wills or the codicil, between the two documents, if the only change is the office of executor, that right to earn fees is not enough to give you standing. You actually, in this scenario, the black and white complete right answer is you can't oppose that other petition for probate. There's no change in beneficiaries. It only changed executors. Your right to compensation isn't enough to confer standing upon you. That kind of makes sense, right? So do you want to do, we're here with like only a few minutes left. It's probably enough time to sneak in another hypo. So does anyone have any other questions that you just want to throw out there? We got a sitting judge.
And we can, if you guys maybe send Lorianne or I or Noreen an email, and don't send the emails to Judge Cowan. If you have questions about the remaining hypos in our scenarios, just let us know, and we'll try to answer them to the best of our abilities.
Well, thank you, everybody. It was a great, we really enjoyed
Oh,
it.
does this mean I don't get a question?
Thank you, everybody, for coming. Thanks for coming to the conference, and we'll see you next year in Riverside.
By the way, we have leftover hypos. If you want to put on your review, if you would like us to come back and do a part 2, I don't know if we can grab Judge Cowan again, but let us know because we can maybe come back and do this again and finish up the rest.